Hello, you're watching Addleshaw Goddard's Employment Channel. We've had a flurry of redundancy cases from the Employment Appeal Tribunal recently, so we're going to look at a few of those today, including whether there can be a redundancy situation when there's no reduction in headcount, and how closely a tribunal can examine an employer's scoring in a redundancy selection process. We'll then leave you with some highlights of the latest proposals to reform the Employment Tribunal's rules of procedure. More on that later. So first up today then is the case of Pachman and Fauchon, which looks at whether a reduction in an employee's hours can constitute a redundancy, even where the number of employees stays the same. As you're probably aware, redundancy is potentially a fair reason for dismissal in unfair dismissal claims. Also, employees who are redundant may be entitled to a redundancy payment. As a result then, it's very important to be able to identify when exactly there is a redundancy situation. In the 2003 case of Aylward and Glamorgan Holiday Homes, the EAT had previously said that there did need to be a reduction in headcount for there to be a redundancy situation, although this decision has been widely criticised ever since. In this case then, Miss Fauchon was a bookkeeper at Pachman Lucas Associates. When a downturn in business coincided with the introduction of some new accountancy software, Pachman had a reduced need for Miss Fauchon's services. They asked her to reduce her hours, but she refused and Pachman ultimately dismissed her. Miss Fauchon brought proceedings against Pachman, and the Employment Tribunal found that she had been dismissed by reason of redundancy. In coming to this decision, the Tribunal ignored the EAT's widely criticised decision in Aylward. Pachman appealed, arguing that the EAT's decision in Aylward was a binding authority and should have been followed by the Employment Tribunal. However, the EAT agreed with the Tribunal and clarified that there does not need to be a reduction in employee headcount for there to be a redundancy situation. In coming to their decision, the EAT said that it was important to focus on all the words in the relevant legislation and not on one aspect only. There may be situations in which the needs of the employer's business are for fewer employees to do the same amount of work, and if employees are dismissed for that reason, they are dismissed by redundancy. However, if the amount of work available for the same number of employees is reduced, as it was in this case, then a dismissal of an employee caused wholly or mainly for that reason can still be a true redundancy. Rosie Kite, an associate in our employment group, is here to discuss what this case means for employers. So Rosie, what should we make of the EAT's decision then?
Well, we had hoped that the decision would give us some much needed clarity. The Aylward case had been widely criticised by commentators. It doesn't make sense really for there to be two employees' hours reduced by 50% and then not to be a redundancy situation, but if one employee was to be dismissed, then that would be a redundancy situation. The EAT agreed with the criticism and pointed out that employers do look at full-time equivalent approach, so they look both at a reduction in hours and a reduction in headcount. Where an employer cuts two employees' hours by up to 50%, but doesn't decide to dismiss an employee, there could still be a reduction in headcount that could result in a redundancy payment.
Sounds like it could be bad news for employers. Does that mean more redundancy payments?
Potentially, yes, but it does depend very much on the facts of each individual case. Yeah. If an employer wants to reduce the number of employees, then or the number of hours, and not dismiss one employee, then there may not be a redundancy payment needs to be made. But if an employee is dismissed after a reduction in hours because the employee doesn't agree to that reduction, then that could be a redundancy situation and it could result in the need to pay a redundancy payment. Like I said, it does depend on the facts of the case though. There has been another case just recently on redundancy as well.
Thank you very much, Rosie. That's right. Shortly after the Pachman case, there was the case of Welsh and the Taxi Owners Association, heard in the Scottish Employment Appeal Tribunal. In that case, Miss Welsh, a taxi radio controller who worked night shifts, was also asked by her employer to reduce her hours following a downturn in business. Miss Welsh didn't agree to the reduced hours and resigned due to the attempts to vary her hours, bringing a claim in the Employment Tribunal for constructive unfair dismissal. The tribunal stated that there was no redundancy situation here because the Taxi Owners Association's need for radio controllers hadn't ceased or diminished. They still needed the same number of employees to carry out the work. Ms Welsh appealed to the EAT in Scotland, arguing that she should have been made redundant. Here the EAT's decision actually centred around whether or not Ms Welsh had been constructively dismissed, rather than whether there was a redundancy situation. However, as Ms Welsh raised the issue of redundancy in her appeal, the EAT considered it as a side issue, and in doing so agreed with the tribunal that there wasn't a redundancy situation here. In coming to this conclusion, the EAT approved the Aylward case, agreeing that the focus should be on whether or not there was a reduction in the number of employees required to carry out the work. Don't you think that contradicts what was said in the Pacman case then, Rosie?
Yes, I think it does really. The President of the Employment Tribunals for England and Wales heard the Pacman case, and the Welsh case was heard by the President of the Scottish Tribunals. So they're calling this a bit the war of the two presidents. However, the EAT's decision on Pacman did revolve around the issue of redundancy situation, whereas the Welsh decision didn't. And so really, I think in terms of where employers should be looking at falling, it would probably be to follow the Pacman decision rather than the Welsh decision, just because of that. Given the uncertainty, though, I wouldn't be surprised if either or both of these decisions were appealed to the Court of Appeal.
Thanks, Rosie. Well, we'll keep you updated of any developments in this area. Next, we look at another redundancy case from the Employment Appeal Tribunal, Nichols and Rockwell Automation, a case which looks at how much a tribunal should scrutinise an employer's scoring system from a redundancy process. In this case, Rockwell wanted to reduce its number of field service engineers. Rockwell used a very detailed scoring system to score those in the pool, looking at a number of different abilities and competencies. Scores were given by one manager and then checked by another. Mr Nichols received the lowest score by quite some distance and was therefore chosen for redundancy and dismissed. Mr Nichols successfully brought a claim for unfair dismissal against Rockwell at the Employment Tribunal. The tribunal conducted a detailed analysis of the scores awarded to Mr Nichols and thought that some of the scores were far too low. The tribunal found also that some of the scores in the scheme weren't objectively verifiable. Rockwell appealed to the EAT, who allowed the appeal and overturned the tribunal's decision. The EAT found that the tribunal had wrongly substituted its own opinion for that of Rockwell's. The EAT said that the tribunal shouldn't have scrutinised the individual scores once it had decided that the overall scoring system was fair. The EAT also endorsed the decision in a case from earlier this year, Mitchells of Lancaster and Tattersall, which said that subjective selection criteria could be appropriate in some cases. I thought I'd ask Chris McAvoy, an associate in Addleshaw Goddard's employment group, for his thoughts on this case. So Chris, what do you think this means for employers?
I think it's a really helpful case for employers. It provides some protection from over-enthusiastic tribunals who may want to look into the detail behind the scoring process. I think as long as the scoring system as a whole is fair, the tribunal shouldn't delve into the detail behind the scoring process, or as they did in this case, substitute their own view for that of the employer. I think it's also a reminder that subjective criteria can be used as part of the process, providing it's applied in a fair and transparent way.
Thanks, Chris. Thanks, Chris. So, to wrap things up for today, we're going to finish by having a quick look at the latest proposals to reform the Tribunal Rules of Procedure. Mr Justice Underhill, the former president of the Employment Appeal Tribunal in England and Wales, has now concluded his review of the Tribunal's Rules of Procedure and has made his recommendations and new draft rules available. Once again, Chris McAvoy has kindly agreed to run through some of the highlights of the proposed changes.
One big exciting proposed change is the introduction of what's called a SIF stage, where basically an employment judge will consider at an early stage whether the claim should be struck out on the basis that it has no reasonable prospects of success. The judge will also list directions quite early on in the proceedings to enable the parties to focus their minds at an early stage. I think this could be really good news for employers because judges will be able to weed out the weaker claims at an early stage, and obviously in doing so saving costs.
Good news. Are there any other proposed changes we should also know about?
Yeah, there's a couple actually. One of which is simpler drafting of the tribunal rules of procedure. Another is timetabling hearings so that, for example, witnesses' time on the stand can be restricted to enable the hearing to be done in one day if it's listed for one day. Another change is the automatic dismissal of claims once a claimant is withdrawn, because at the moment a separate application needs to be made.
Thanks, Chris. A formal consultation on the changes to the rules will follow this year. We'll be sure to keep you updated on progress. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.